Start. The main object of Article 16 is to create a constitutional right to equality of opportunity and employment in public offices. The words employment or appointment cover not merely the initial appointment but also other attributes of service like promotion and age of superannuation, etc. The appointment to any post under the state can only be made for after a proper advertisement has been made inviting applications from eligible candidates and holding of selection by a body of experts or a specially constituted committee whose members are fair and impartial through a written examination or interview or some other rational criteria for judging the inter se merit of candidates who have applied in response to the advertisement made. A regular appointment to a post under the state or union cannot be made without issuing advertisement in the prescribed manner, which may in some cases include inviting applications from the employment exchange or eligible candidates get their names registered. Any regular appointment made on a post under the state or union without issuing advertisement inviting applications from eligible candidates and without holding a proper selection where all eligible candidates get a fair chance to complete would violate the guarantee enshrined under Article 16 of the Constitution. Thus, it is clear that adherence to the rule of equality in public employment is a basic feature of our Constitution, and since the rule of law is the core of our Constitution, a court would certainly be disabled from passing an order upholding a violation of Article 14 or in ordering the overlooking of the need to comply with requirements of Article 14 read with Article 16 of the Constitution. Therefore, this court, while laying down the law, has necessarily to hold that unless the appointment is in terms of the relevant rules and after a proper competition among qualified persons, the same would not confer any right on the appointee. It was further observed that it has also to be clarified that merely because a temporary employee or a casual wage worker is continued for a time beyond the term of his appointment, he would not be entitled to be absorbed in regular service or made permanent merely on the strength of such continuance. If the original appointment was not made by following a due process of selection, it is not open to the court to prevent regular recruitment at the instance of temporary employees whose period of employment has come to an end, or of ad hoc employees who, by the very nature of their appointment, do not acquire any right. High courts, acting under Article 226 of the Constitution of India, should not ordinarily issue directions for absorption, regularization, or permanent continuance unless the recruitment itself was made regularly and in terms of the constitutional scheme. The question of regularization of the services of such employees may have to be considered on merits in the light of the principles settled by this court in the cases above referred to and in the light of this judgment.